which is the basic and fundamental rights of every aggrieved party, and a redressal for is any grievances relating to the criminal liabilities may go to the concerned SHO, uh, may be uh, heard his grievance relating to any offense. And now I want to share with you the offense are two types. One of the cognizable offense and one of the non-cognizable offense. In non-cognizable offense, SHO may not register the FIR, but he may register his contention and his complaint in the uh, daily Roznamcha diary. And relating to the second type of offense is called cognizable. And related to the cognizable offense, SHO may register his complaint in registration book of the criminal cases, which is available in every police station. And if offense is relating to the cognizable offense, and this all the proceedings deals under section 154 of the criminal procedure code, and under section 154 of the criminal procedure code concerning SHO is mandatory and obligatory upon, and it's he is duty bound to register the FIR first information report relating to the cognizable offense. If the contents from the application moved by any complainant, uh, it shows and depicts from the contents of the complaint the offense is relating to the cognizable, then the concerning SHO is duty bound to register the FIR before any interrogation or before any investigation. It is the first step, and without causing and without any delay and without any excuse, the concerning SHO is duty bound to register the FIR for safe and sound administration of and dispensation of the criminal justice. And first information report basically comes law into motion at first without any deliberation and without the elements of any concoction and without the elements of any fabrication. Uh, and after that, all the criminal proceedings as per mentioned in the relating sections of the criminal procedure code may be stepwise, may be initiated through uh, criminal courts of the country. Now, the section 154 of the criminal procedure code, uh, in the main provision, it's clear cut mention the word shall. Shall depicts the intent behind the legislation, that SHO has no option left behind for its refusal if the offense relating to the cognizable offense. Now, SHO is duty bound and it's mandatory upon the SHO to register immediately and spontaneously the FIR and register the criminal case against offender or culprits or criminals. Now, if the concerning SHO refused the contention of the complainant relating to the cognizable offense due to some excuse, the complainant party or aggrieved party for the redressal of his grievances may refer his matter to the criminal court, which has empowered additional session judge on the having jurisdiction to entertain his application against the refusal of the concerning SHO for registration of a criminal case. The Justice of Peace under section 22A subsection 6 has empowered to issues direction for the registration of the criminal case after applying and exercising his judicious mind, because he has an administrative power. And after that, later on, so many Supreme Court's judgments which has been discussed in detail. The Justice of Peace has powers of the Justice of Peace is administrative power or judicial power or quasi-judicial power. But after that, later on, it is thoroughly discussed by the Supreme Court of Pakistan, the powers of the Justice of Peace is quasi-judicial power, because he is, after exercising his judicious mind, may issues direction to the concerning SHO for his administrative function may be implemented uh, immediately without any delay. Now, the concerning Justice of Peace may entertain his application and uh, of without calling any comments from the concerning SHO may exercise his judicious mind and see first of all the contents of the application are moved by the applicant, whether it depicts the offences relating to the cognizable or not. And if contents from the complaint it depicts clearly that the offence relating to the cognizable, then Justice of Peace has completely and ample power to issue direction to the concerning SHO for registration of criminal. Second FIR issue direction to the concerning SHO. And Justice of Peace has no import to issue direction for specific and particular manners which may be adopted by the concerning SHO. Now, in another situation, the concerning Justice of Peace may not issue directions to the concerning SHO for addition or deletion of any offense from the contents of FIR, which may be depends upon, but it is the duty of the district prosecutor. The Section 9, Subsection 7, Punjab Prosecution Criminal Services Act 2006, and it is exclusive domain of the district prosecution to add or delete any offense. Hello, my dear viewers or friends, it is the ample power of the Justice of Peace to issue direction after its complete satisfaction from the complaint moved by the applicant, depicts from the pros and cons of the and from the contents of the complaint it depicts clearly offense relating to the cognizable offense. Then Justice of Peace, if is completely satisfied after exercising his judicious mind, may issue direction to the concerning SHO. And Justice of Peace may rely upon the comments moved by the concerning SHO from his contention of his refusal to register the FIR, may be relied by the Justice of Peace on comments moved by the concerning SHO. Power. And in this regard, so many relevant judgments on this topic I want to share with you after all my these uh, most important corners after discussing with you. Now, my dear friends, um, the first step of redressal in FIR, because I want to share first of all the FIR is the basic document in criminal proceeding, which means first information report. Now, the basic purpose of the FIR I have discussed already is to set criminal law into motion and to adhere first-hand spontaneous information about occurrence. In order to exclude probability and fabrication, deliberation, and concoctional elements regarding cognizable offense, spontaneous of FIR discourage the outset elements of false implication and provide guarantee of truth to a great extent. This already has been discussed. The judgment of the Supreme Court is most famous judgment, 2011 SCMR page 45. No, the second judgment is very important related to the FIR under section 154 of Criminal Procedure Code. Already discussed this topic of FIR, which my viewers are with my audience. Section 154 of Criminal Procedure Code being obligatory and mandatory in nature. In this section, SHO has no option to refuse to register the FIR if contents of complaint disclosed commission of a cognizable offense. This already has been discussed in the landmark judgment of the High Court 2006 PCRLJ page 622. FIR is not a substantive piece of evidence and can only be used to corroborate and contradict his maker. This already has been discussed in most famous judgment 2003 PCRLJ page 1776. FIR is the first step after the commission of a cognizable offense in case of refusal to register of FIR concerning SHO1 when relating to a cognizable agreed party file an application for justice of peace. I have already been discussed with my dear audience. Now, I want to discuss with you most famous judgments regarding to the powers of the justice of peace. And the word shall already mentioned in section 154 of the for the registration of the FIR. Change section 154 of criminal procedure codes depicts the intention of legislation. I have already been discussed with my viewers. SHO is duty bound to register criminal case if offense is cognizable. Refusal is out of question. It's being obligatory and mandatory in nature. It already has been discussed. The most famous judgment, 2006 PCRLJ, page 622. These four judgments, it's very important to share with my viewers or audience. But in case of refusal, aggrieved party may file application under section 22A subsection 6 of the criminal procedure before justice of peace section. The session judge, additional and session judge, justice of peace direct the SHO to register FIR regarding occurrence relating to the cognizable offense. It already has been discussed. I want to share with you some judgments, most important judgments. This very important corner here already has been discussed in the light of the judgment. PLD 2007 Supreme Court page 539, 2010 PCRLJ page 1466, 2005 YLR page 3297, PLD 2005 Karachi page 285, 2007 PCRLJ page 145, NLR 2005 Karachi page 285, PLD 2005 LHR page 470. Um, the SHO concerning SHO is duty bound and obligatory upon, and it's binding upon the SHO to register the FIR under order 2000, under police rule or order 2002 under article 18 subsection 6. This is the most relevant reference my viewers have to knowledge about this provision of law. Police Rule Order 2002 under Article 18 subsection 6. Concerning SHO is duty bound and it's mandatory and obligatory upon, it's compulsory upon the SHO to the registration of the FIR is the out of question. This already has been discussed. The most famous judgments 2011 YLR page 2141, 2011 YLR page 2141, 2010 PCRLJ page 1466, PLD 2006 Lahore page 460, PLJ 2005 Lahore page 1571, 2004 YLR page 56, 2008 YLR page 2301, 2008 MLD page 1142, PLD 2008 Peshawar page 53, PLD 2008 Peshawar page 1. In all these, in the lights of all these judgments, it's very much clear. The SHO has no option for refusal to register FIR relating to the cognizable offense. Now, my viewers, my dear viewers and respective friends, I want to discuss the justice of peace may dismiss the application if considered meritless. This specific corner is also discussed by the Superior Court's 2008 YLR page 2301 and justify to turn down the request of the applicant and not issue direction to the concerning SHO. It already has been discussed in this these landmark judgments. 2011 YLR page 1768, PLJ 2012 CRC Quetta page 581. If concerning SHO submit a report in favor of his refusal, then justice of peace may pass order for direction contrary to the report of the police. These most important judgments, my viewers and audience have knowledge about it. 2007 2007 PCRLJ page 1935, 2006 PCRLJ page 1775. Justice of Peace may issue direction without report of police. Effective disposal not warranted. 2005 YLR page 1610. Now, the delegation of power or authority to the SHO by the Justice of Peace, specifically, he is delegated some powers to the concerning authority or police authority or concerning SHO to do a specific manner or in particular manner something. It's not warranted by law. This specific corner already discussed by the superior courts, PLD 2009 Lahore page 232, 2008 YLR page 2406, PLD 2007 Lahore page 53. Now, Justice of Peace without hearing of defense side accused party may issue direction to SHO, and notice is not required to person against whom action may be initiated or required. Justice of Peace not obliged to hear the accused. In this situation, the principle odi ultram partem is not applicable. In this situation, when the Justice of Peace has exercised its administrative function. PLD 2000, PLD 2000, Lahore, page 208. And in the Superior Court Judgment 2004 PCRLJ, page 1214. In both judgments, it's this specific corners already has been discussed in detail. And my audience and listeners and law students may consult these both judgments. Is very much important. PLD 2000 Lahore, page 208, 2004 PCRLJ, page 1214. Accused person have no right of hearing. This specific corner is one of the Superior Court Judgment 2002 PCRLJ, page 9. Is specifically discussed in detail in this judgment. Justice of Peace may pass order for second FIR. I have already been discussed and shared with my viewers. PLD 2009 Lahore, page 8. 2011 YLR, page 883. Justice of Peace may pass order of issues direction and can issue directions even in non-cognizable offense, which is already I have been shared with you prior to this. And no bar existed under section 1552 of Criminal Procedure Code. Is discussed in detail the Superior Court's judgments. Both of the judgments I want to share with you. Reference of the judgment. Superior Court Judgment 2012 PCRLJ, page 981. 2012 PCRLJ, page 981. And second one is 2008 PCRLJ, page 1358. And after exercising the judicious mind by the Justice of Peace, and when he is completely satisfied, then issues the direction to the concerning SHO for registration of the criminal case. Is already discussed the one of the most landmark judgment, Karachi High Court, PLD 2009 Karachi, page 14. Justice of Peace can suggest to adopt any specific and particular procedure or manners, means first to interrogate, etc. Then after interrogation you may register the FIR. Such like specific directions may not issue, cannot be issued by the Justice of Peace, and its embargo upon the power of Justice of Peace cannot suggest to adopt particular procedure. This very much and most important corner discussed in the Superior Court Judgment 2011 YLR, page 2141. Compliance of order of the Justice of Peace must have been complied with in its true spirit and its true letter and spirit. SHO has left no second option after direction of the Justice of Peace. This very much important corner already has been discussed in the Superior Court Judgment, in the light of the Superior Court Judgment, which want to be quoted. 2012 PCRLJ, page 180. If Justice of Peace refused to issue direction to concerning SHO, Yeah, Justice of Peace may refused to issue direction to a concerning, then aggrieved party has an alternative remedy to file private complaint under section 200 of criminal procedure code. This very much important corner already discussed in detail by the superior courts of the Pakistan. 2011 PCRLJ page 3906, 2011 PCRLJ page 1870, PLD 2007 Supreme Court page 539. Justice of Peace cannot issue directions for addition or deletion of any specific offences which has been depicted from the contents of the complaint moved by the complainant. This very much important corner already have been discussed in detail by the superior courts of the country. 2012 PCRLJ page 873, PLD 2008 Lahore page 135, 2008 YLR page 2017, 2006 YLR page 2772, 2007 PCRLJ page 124. These, in the light of these five judgments, the Justice of Peace has no issues, issue and directions for specific added or deleted to any offense. Uh, Under Section 9, subsection 7 of the Punjab Criminal Prosecution Services Act 2006 is very much relevant to specification of the relevant, very much relevant. District prosecutor has exclusive domain for addition or deletion of any section under Pakistan Penal Code, which has been attracted or not. No, my dear listeners or viewers, I think uh, I want to discuss in my next episode with you the most important, most related topic, the private complaint and Challan case. Both of these most important documents and the further procedures which has been required for the criminal proceedings for criminal dispensation of the justice through criminal courts. I want to discuss in next time, inshallah. Okay, Allah Hafiz. Fi aman.